serious issues regarding HB160. Though I support it and it's well-intentioned, there are some issues, I think, as how it's currently written that the committee needs to address. Currently, the dwelling and curtilage language is left in the bill and then added the language of or any place where an actor has a right to be. Statutory construction, what we're creating here is called a justum generis clause. And what it means is of like kind or same. What happens is the phrase, or in a place where the actor has a right to be, becomes dwellings or curtilages or the like. So it will not accomplish the goal that the sponsors set out because the court will interpret it in that narrow fashion. There's case law on this. To give an example to understand what a justum generis, imagine a law saying, a law banning the carrying of pistols, revolvers, derringers, or other dangerous weapons. The court would interpret the phrase under justum generis, other dangerous weapons, as being firearms, and probably more narrowly as being handguns. So when you have the language read as proposed in the current bill, that of a felony against the actor within the actor's dwelling, comma, its curtilage, or in any place where the actor has a right to be, it doesn't achieve the goal. Now, whether you want that goal achieved or not, that's another story, but it needs to be changed, and I would suggest striking in its entirety the dwelling and curtilage language. Because if you have a right to be in your home or on curtilage, then you have a right to be, instead of creating a justum generis clause, which I believe is a flaw in the bill. Additionally, concerning how the phrase a right to be gets interpreted, what does that mean? And I might suggest adding some language to a right to be, because what if you are inadvertently in a place where you shouldn't be, such as you're illegally parked, or outside a crosswalk, or some place where you thought you had a right to be, but didn't. Now I understand wanting to have language of being in a place you have a right to be, because you don't want to justify wrongdoers and giving them a right under this. But on the other hand, surely you could see there could be otherwise law-abiding citizens who might get stuck in this, and you wouldn't want to have that problem. So I respectfully suggest that. In New Hampshire, in order to raise self-defense as a defense, it is raised by, in a criminal matter, by giving notice to the state, and then all the defendant has to do is show some evidence, and that's the actual law. It's State versus Vassar. I have the case on the materials I'll give to the committee. As long as you can show some evidence, then the state does have the burden of proof to prove that beyond a reasonable doubt and negate the elements of self-defense. So that is there. But as the Attorney General, and Attorney General did testify to that, but also testified there may be some times or occasions where self-defense, such as in a vehicle and then the use of deadly force, what wasn't mentioned there, and it goes to Representative Ryder's question, if you have that right to use deadly force in the face of deadly force, you still have the Part 3 problem, and that's what this bill is attempted to address, the right to retreat. So as Representative Welch pointed out, what if you're in the middle of a carjacking? The Attorney General said you have a right to defend yourself, as long as you could not retreat in the face of that carjacking. So that becomes the legal question. And what this bill attempts to do, but needs some amendments to make it work, is avoid the need to retreat in the face of such a carjacking, where the Attorney General specifically recognized, hey, you have that right to defend yourself, but what if we don't have such a reasonable Attorney General at that time, and one who decides to enforce the law in a way that none of us sitting here wish it to be enforced? It reminds me of a story of a person who pulls up to the service station. The person says, hey, the mechanic, your tire needs, the nuts need to be tightened. Your tire is very loose. Oh, don't worry, I'll wait till it falls off. It hasn't fallen off yet. Well, that's not very smart. You want to address and preempt things in advance. Avoid a law-abiding citizen being tormented in this way. And it can be done. So I respectfully make those suggestions, and also I would point out that there is what would be a typographical, I believe, error where it talks about amendment of, right in RSA 627:4, and it says 111A. I believe it meant to be III, section 3, Roman numeral 3. So there is a typographical error that I pointed out. The Attorney General further testified about that there is a presumption regarding self-defense. And that is really referenced in the case law. Like I said, all you have to do is present some evidence, and then the state has to disprove by proof beyond a reasonable doubt. But the presumption has not been codified. That presumption is not found in the statute. So what I respectfully suggest is adding simple language to it, codifying what is known in case law to the degree a person is presumed to be justified in using deadly force. And there are other jurisdictions who have passed this type of law that have put the presumption directly in the law, even though it does exist by way of case law in New Hampshire, to further enshrine it and make it clear. All I would thank the committee for.
You have written.
Oh yeah, I've written materials. Thank you.
Are there any questions, please? Representative question?
Yeah, I have a question. It relates to the burden of proof or the standard of this. Now, there's a presumption that defense is justified, and the state has to prove beyond a reasonable doubt that it wasn't justified.
Yes, what happens is there is a burden of proof for all criminal cases. As a matter of fact, burdens of proof start off as suspicion, then go to probable cause, then preponderance of the evidence, clear and convincing, and the highest burden of proof, proof beyond a reasonable doubt. The very highest burden is reserved for criminal cases. Well, when the elements of the offense that have to be proven by the state have to be proven by that very high burden. When a defendant puts forward a defense of self-defense, and they do it by simply sending a notice to the prosecutor, I'm raising self-defense, and then presenting some evidence, more than a scintilla, but that's it, some evidence, then the jury instruction on self-defense has to be given to the jury, and the state will have the burden to prove beyond a reasonable doubt to negate the argument of self-defense. And that is how it works, and the case law to look at on that, which I cite in the papers, is State versus Vassar, which is a very recent, within the last couple of years, right on point on that.
Follow-up? Yeah.
I know under the first one, the general rule, it states that if the such conduct is justifiable, it shall constitute a complete defense to any civil action based on such conduct. Does that mean if you're found to have been justifiable just in using force beyond, and the state couldn't prove it beyond a reasonable doubt, does that preclude a civil suit against an individual where the standard might just be a preponderance of evidence?
Yes, that would be my, yes. What it does is you will not have to face the civil based on your acquittal criminally, which is a statute not addressed in this bill at all, but yes, that's my understanding as well.
So if this measure is adopted and a shooting takes place outside of the castle, in a public area, say someone uses self-defense at a high school football game and somebody else in the process also gets taken out with the attacker, if found that it was reasonable beyond, if it was found that it was justifiable, would that preclude any other civil suit from anybody else who might be injured in the party?
I don't know the answer as to whether the parties that were not the aggressors, in other words, an accidental death or injury of a third party, is in fact covered by that law. I don't know the answer.
Representative Roth.
Yes, thank you. I'm wondering if you might be able to tell us, say, in the last 5 years, how many people have been successfully prosecuted for using deadly force when it was deemed unnecessary?
Oh, you mean were wrongfully prosecuted? Well, I'm sure the Attorney General will say none, but I guess that's a subject of opinion. But I would say that you don't want to have someone wrongfully prosecuted. No reasonable person would. And so, if this law helps to accomplish that, then that's why.